Right.
There you go. Come right here. You're good. Oh, nice. That's it. Nice. That.
Wait, hold on.
Hey, good morning, Robert. Could you mute, please? We're getting a lot of feedback from you. Thanks.
Good morning, everyone. Just to apologize for the delay in the start. We're having a bit of a technical difficulty in terms of the streaming, so we're asking you to give us 5-10 minutes, please. Thank you.
Good morning, everyone. This hearing is now called to order. Let me first apologize for the slight delay, but we just wanted to ensure that persons who are joining us online would have been able to access the meeting. At the conclusion yesterday, we would have heard the applicant as well as the interveners. This morning, the applicant will be permitted 45 minutes to reply to the interveners' submissions on the threshold question and the motion. I now invite Mr. Aline to make his presentation.
Thank you, Chair. In giving some structure to this response, I will first seek to deal with the submissions of the interveners separately, and thereafter speak to some overriding themes which have either been misstated or mischaracterized, at least as the applicant feels, by the decision and as interpreted by the interveners. Intervenor Watson and Simpson made a number of arguments, many of which, in my opinion, were somewhat skewed in terms of their interpretation of fact and law. So, for example, the idea that by writing the FTC, the self-insurance fund, the applicant imbued or recognized this commission's jurisdiction over the matter is somewhat a false concept. The legal realities which will be known to my friend would be that such jurisdiction can be only granted by the legislation. And as a commercial practitioner, good common sense would suggest that if you represent a regulated entity, you reach out to the regulator when indulging in any act that may cause their interest and ensure that your actions are accepted and agreed to be above board. That's just good common sense and good practice. Much ado was made in relation to paragraph 68 of the decision, where the commission made certain findings in relation to the quality of evidence put forward on the issue of generators. And I say on the issue of generators because it's specifically related to that item under consideration. It was not highlighted as a statement of the overall evidence of the applicant, at least not as written. However, and unfortunately, the interpretation given by a number of the interveners is the exact reason why the applicant took issue with these statements within the substantive grounds that we would have filed. At no time did the commission give an example of the lack of transparency, which is the complaint within that paragraph. It therefore calls the finding into question because in failing to give any supporting factual reference, it is not a finding on which the commission or any of the interveners can rely. It is a part of your obligation in crafting the decision to indicate, if I'm going to say this is lacking in transparency, I found this at paragraph X, I found this at interrogatory Y, I found that Mr. Blackman didn't answer. That is the type of evidence that would need within the decision to support that finding. The effort to somehow impugn the character and practices of the applicant went so far as to indicate, and this is now from intervener Watson, that the summarized spreadsheet with the relating data embedded therein, as you would expect in an Excel spreadsheet, is somehow an attempt to hide data. Now, if the person is as incompetent as I am in using Excel, that may explain it, but certainly I don't know that's a limitation of the commission or anyone who is seriously making an effort to analyze an Excel spreadsheet. There's been an effort to rewrite the arguments of the applicant, such as the idea that the applicant alleges that since there was a failure in the past action to action certain sanctions, there's an inability now to act on them. That's the argument. You failed to act before, so you can't do it now. We never made that argument. The applicant has said that it should be reasonably able to rely on the clear statements issued by the regulating entity. Certainty, a matter my friend the Public Counsel speaks to, and I will get to it. There is then the further argument that since the legislation on the self-insurance fund sets out purposes for the use of the funds, and paying dividends is not one, that it is a breach of the legislative guidelines in terms of what occurred with the self-insurance fund. Again, this is a mischaracterization of the applicant's position. We argue that funds once within the fund are controlled by the legislative guidelines and the relevant trust document. Funds once withdrawn and delivered to the appropriate beneficiary as stated in the trust document, in this case Barbados Light and Power, are not subject to the purposes set out in the legislation. On the issue of legitimate expectations, there is a quote from Professor Eddie Ventos to support an argument that there can be no legitimate expectation where the expectation is unlawful. And let me say that I totally agree with this statement. The actual quote from Professor Ventos is, "The Commonwealth Caribbean courts have made it abundantly clear that such expectations have no legitimacy and could not be held valid in the face of a statute making an action itself unlawful." In the face of a statute making itself unlawful. No statutory provision has been placed before this commission to indicate that it is unlawful for the applicant to rely on a statement from the commission that it has no jurisdiction, or that the batteries were prudent. Don't just quote sections without going to the core, substantive, singular element that is necessary for the analysis. Provide me the statutory limitation. Then in what I can only consider to be a tongue-in-cheek reference, the idea of promissory estoppel is thrown out as an argument against the applicant that bounds the applicant's use of its assets once lawfully withdrawn from the self-insurance fund. I say tongue-in-cheek because I am sure that my friend is aware that promissory estoppel cannot be used as a sword in English common law, but only as a defense for some action taken against an individual. Promissory estoppel is not a cause of action. You can't use promissory estoppel to entitle you to anything. You use promissory estoppel to defend yourself. I will leave the issue of the reductions in the SIF when dealing with a similar argument put forward by the Public Counsel. But before then, I must reference an example utilized by Ms. Watson to give a particular impression without, in my opinion, giving the whole picture. She argues quite convincingly on the face of it that the applicant put forward the case that it needed to manage its revenues as expenses were increasing, and this influenced its decision not to fund the SIF. And she points out that the expenses were approximately $3 million less when comparing 2011 to 2009. The argument being, well, look at 2011. You actually had less expenses. Now, for the accountants in the building, they would well be aware that there are two sides to an income statement. And what she did not put to the commission when she made that reference was that in 2011, the revenues were approximately $6.5 million less than 2009. Another situation where you choose to look at one side without putting the full picture. So yes, there was a pressure relating to expenses. And I will come to the issue of the earnings of the applicant in the years post-2010 to speak on another matter that I think is critical to the Commission's consideration. Intervenor went. I have no shame in admitting that the issues and numbers raised by Mr. Wendt were in some manners above my head. And I won't seek to confuse myself any further. What I would say is that none of it is relevant if the applicant's argument concerning its right to deal with the funds after their withdrawal is accepted. What interest rate you pay, what interest rate you pay if it's X money, what interest rate you pay if it's Y money, all of that is irrelevant if the argument is recognized that the applicant had the right in terms of the withdrawal. And we will deal with the applicant's right in that withdrawal when we deal with the public counsel. What I must respond to, however, in terms of Mr. Wendt's submission, is that as it relates to test year. Again, there's a mischaracterization that the applicant has taken issue with the Commission's ruling as to what is an appropriate test year. Any reading of our filings would indicate that is not the case. And I know Mr. Wendt, with all his capabilities, is able to understand the difference. The applicant has taken issue with the Commission seeking to make a certain period the test year to take care of the issue of abnormal revenues, while not taking the same care to ensure they are matching expenses to be considered when making necessary adjustments. That is the argument of the applicant. We take no issue with the determination of the Commission as it relates to the set test year. We say you need to go further and assess certain other adjustments. We've made clear the law relating to that matter in my initial presentation. Lieutenant Colonel Brown. I consider Lieutenant Colonel Brown a friend. And from the time of the rate hearing, he made it clear that he's no lawyer. He was very proud of it, actually. And I believe he has no interest in being one. However, he does take a certain comfort in making statements such as, quote, illegal defunding, close quote, when referencing the withdrawal from the SIF. No evidence is before this Commission that supports an allegation of illegality, and I don't believe that the Commission's decision suggests any such illegality. There's no breach of trust, there's no breach of the enabling legislation, and there's no breach of any direction of the FTC. So let's put that to bed. Illegality is not a concept here. It is loose and dangerous language, and I can only assume it is issued to excite persons who may not know all the facts. He delves further into legal principles, given his interpretation of Section 22 of the URA. And as he said, he is no lawyer. So I will not interpret his failure to say that Section 2 deals with a service provider ceasing its operations and only those circumstances. This was not an effort, I would imagine, to mislead the Commission. But however, it is another example of loose language. I will not say misdirection when Colonel Brown indicates that if funds are, to his words, misused, then you pay taxes. The relevant Section 8.2 at no time references the concept of misuse of funds. A theme of loose language, a theme of easy language, which is, as I said, only used to excite certain persons, but I don't know that it necessarily will work on the Commission. The Commission, at the end of the day, actually has to look at the legislation and make an assessment of what it says. Again, like previous interveners, Lieutenant Colonel Brown falls into the misunderstanding that limitation on the use of money within the fund somehow apply to the monies once withdrawn. That is a false concept. Now, Colonel Brown is, by my understanding, also not an accountant, but he repeats a popular untruth that he has previously made during the rate hearing, that the shareholder has made no investments in the applicant. It's a theme of Lieutenant Colonel Brown. It's a well-accepted accounting principle that retained earnings represent an investment by a company's owner in the entity. And where the level of retained earnings in the applicant as at December 2022 stands at over $300 million, it is a substantive investment. So it is an untruth that the Colonel needs to stop propagating. Finally, in a suggestion which I'm comfortable the Commission will not follow, my friend argues that the Commission has a power of retroactive rate making, even though it's prohibited by core legal principles of law and fairness, not just regulatory law, general law. He's not interested in legal requirements. His base argument is that you should do what you wish because the applicant might not be here in 2028. You gotta do it now. You gotta rush it and do it now. As the old people would say, you should be careful what you wish for. The Public Counsel. I understand and recognize the limitations under which my friend, the Public Counsel, has had to operate, given his limited time in that role. However, my sympathy does not extend to the idea of giving him free rein to mischaracterize the facts or confuse this Commission as to the process and the matters upon which it must pronounce. So what did he do right? He actually was right on one concept, and he started off quite correctly. And I must say that I concur with him wholeheartedly when he argues for the presumption of finality in decisions. Any review of the applicant's filing herein will highlight that this is a theme that runs through many of the arguments related to the issue of SIF, related to the issue of the 5 megawatt ESD, related to deferred tax liability. The applicant has not been able to rely on the finality of decisions in this regard, and that is why we are here today. So I agree with him, and I think the Commission should take that point on. But where we diverge and where we conflict is quite substantive. First, he confuses the issue of threshold, which simply relates to the basis at which this Commission will proceed to hear a motion to review. He confuses this with the burden of proof and establishing the case. These are two separate and distinct matters. He goes on to say, quote, during the rate hearing, you can look at all the assets, close quote. We agree, but we also clearly state that the case law does not support an asset grab for ratepayers because of a perceived interest in the right to electric service. And that is the dicta of APCA that I referenced earlier. He offers no legal authority for his positions. In fact, I would say that a majority of the Public Counsel's arguments were premised on either a misunderstanding or a misapplication of the principles in a review such as this. I mean, he actually even asks, why are we here? It doesn't seem smart or logical to come back before you. He questioned that. That's the law. That's the obligation under the statute. That's why we are here. It's not for us to question why Parliament so dictated. That is the requirement in the process. And it speaks to the misunderstanding of the process. He may also be hampered by the fact that he was not present during the actual rate hearing. If he was, the Commission would not have heard issues such as sitting on rights, standing on evidence, lack of objection. I almost felt that I was being taken back to my criminal court days. All these issues are irrelevant and not matters for consideration by this Commission. He conflates the principle of prudence between generators and the SIF. The former, a necessary element of delivering electric supply, and as such clearly within the ambit of the Commission. and the latter clearly not within the ambit of the Commission as it itself accepted and as is clear by the necessary legislation. But somehow these two are apples and apples to be compared. He then equates SIF funds to a constructive trust and sought to apply rules of equity. And I mean, it sounded good, I will say. It did. Sounded reasonable. So then the Commission heard about equitable rules such as come with clean hands. Unfortunately, the Public Council is unaware that there's an actual trust document. There's no need for a constructive one. And there was controlling legislation. And between these two elements, there's no role or place for the Commission to impute rules. There's no evidence that the rules of the trust or the legislation were breached. There's no discretion in this Commission to determine how the trust should run. You look at the trust document. There's no role in this Commission to determine how funds may be withdrawn or if you look at the legislation. We were then taken to the balance of convenience and/or justice. Both were used. Matters solely in the consideration of injunctive proceedings. Issues no longer relevant, seeing that the matter of the stay has been ruled on by the Commission and determined in favor of the applicant. Balance of convenience, balance of justice. This is not an injunction proceeding. He then went to test years, but the comments I have made in relation to my friend Mr. Wendt equally apply to the Public Council. Public Council then sought to compare the ESD and the SIF. And he asked, can the Commission look at the ESD and not the SIF? The simple answer is yes. The ESD falls squarely within the jurisdiction of the Commission in its rate-making powers, and the SIF falls squarely within the jurisdiction of the Financial Services Commission. The answer is yes. He too raises the issue of the Commission statement at paragraph 68 relative to the applicant's evidence in this matter. And as I said, the issue of 68 is that the Commission made a finding but did not give evidence to support that finding. My friend, the Public Counsel, however, well knows that in his previous place, when he gave a decision and disregarded testimony or found it lacking, unless he said why and what aspects of the evidence were questionable, he stood a very good chance of the Court of Appeal chastising him. That is a requirement of the oversight in such judicial proceedings. You can't just say, I believe John is a liar. You have to say, I believe John is a liar because when Mr. Allen asked question X, he stumbled. You can't say, I don't like the interrogatory. You have to say, the interrogatory is lacking in transparency because it did not show these 3 columns of information. That's the requirement. Barbados Association of Retired Persons. Unlike Lieutenant Colonel Brown, Mr. Skeet is a qualified and well-respected accountant by training. So therefore, when he correctly stated that as it relates to accumulative depreciation, there is, quote, great rigor when studies are carried out, and the resultant, quote, more meaningful findings arrived on that basis, I felt assured that he would confirm my position and that of the applicant that their actions in relation to updating the depreciation studies according to IFRS standards was appropriate. It was therefore somewhat contradictory for him to say that he was supportive of the regulatory finding as it relates to accumulated depreciation. It went counter to what he started by saying. Mr. Ski asks what one may consider to be a rhetorical question, and that is, why would the FFC and the Central Bank of Barbados approve the applicant's actions as it related to the SIF? I cannot expand on their thinking. I'm not privy to their thinking. But I can say that the issue before the Commission today is not the reasoning of the appropriate regulator of the SIF, but whether the Commission has jurisdiction to do as they did in this decision. We believe, and we believe we've proved, that the answer is no. What informed the minds of the FFC and informed the minds of the central bank? I do not know, and I wouldn't want to guess. I've already pointed out my friend's credentials in the area of accounting. So when he clearly indicates that the Commission's decision as it relates to debt equity ratio will mean that the applicant will have one of two choices to reach it. That is significant borrowing and or significant payment of dividends. I totally agree and accept his premise. That's the only way you can reach that ratio. This then begs the question whether the Commission is willing to live with these obvious consequences going forward if it sticks with the ordered notional ratio. All of us in here are clear as to the angst caused by the issue of payment of dividends. It was as if the idea of a company or entity getting base reasonable return on its investments was something cannot be accepted or recognized. A company deferred dividends many years, did not take them, but it was still an issue. The Commission's decision says this shall be the notional ratio. In accounts, there are only two ways to reach that notional ratio. In 2 or 3 years when they come to do the borrowing, or in 2 or 3 years when they pay out the dividends to meet it, there'll be a hue and cry. And that brings me to another matter which I consider a significant element permeating all of the submissions of the interveners, permeating a major element of the decision of the Commission, and one which I feel I must spend some effort to make clear, as this may be my last opportunity. And this relates to the issue that the monies withdrawn from the self-insurance fund was ratepayer money. That's a critical element, I believe, at the base of the decision as it relates to the SIF. It's a critical element, as I said, that permeates many of the submissions of the interveners. There has been a focus on the order of the Commission in 2010, whereby approximately the sum of 7.6 million was included in base rate as a contribution to the SIF. Now forgive me if my numbers are a little wrong, but we've heard them enough. I'm not trying to confuse. We've heard, let's take out the number, that there was a certain figure included in base rate in 2010. The complaint is that shortly after, in choosing not to pay the sum into the fund, the applicant has taken or claimed ratepayer money. Let's put it succinctly. We ordered certain monies to go in. You, the applicant, in your mind, managing your costs, managing your affairs, managing your expense payments, decided not to put it there, use it here. I paid salaries, I bought that generator, but I didn't put it into the SIF. Now, let me first deal with the 7.6 or whatever the amount is. That 7.6 does not exist in a vacuum. That 7.6 is part of the revenue requirement that was permitted in 2010. It's linked. You added up all the needs and you came up with a figure of $200 million. 7.6 is part of that $200 million revenue requirement. Okay. What happens if we say the applicant never earned $200 million thereafter? Can you say 7.6 came in? You were awarded $200 million as your revenue account, as your revenue requirement. In 2011, you didn't get 200. Let me go through. In 2013, the applicant received $192 million, 8 million short. In 2014, it was 10.7 million short. In 2015, it was 8.5 million short. If the applicant is getting less than the recognized revenue requirement, where does this idea that 7.6 was paid in and was not paid across to the fund and such is ratepayer money that must be returned? The managing director in his evidence spent time and effort to indicate we run a business. That PAM was to cost $10. It cost $12. We had to add $2 there. The rate hearing has gone. We can't ask you for another $2 to pay for the PAM. We put some money across there. You recognize that this company needed $200 million, and year after year it was not met, it was not received because of diminished sales. That's a fact. The evidence is clear throughout the testimony. How can you then link to say 7.6 was paid in? That was a recognized assessment of an amount that we would put towards that total of $200 million. That is all it was. So year after year, applicant never receives the revenue that it was awarded. I would suggest that means you cannot argue 7.6 was received. But that's a small part of the problem. That's a very small part of the problem. On every occasion where interveners or the commission has dealt with the issue of ratepayer money and the SIF, they start in 2010. They act as if the fund did not exist prior to 2010. They act as if the monies received suddenly only began 2010. 2010 was when an order was made allowing for ratepayer contribution to the SIF. The fund existed many years prior to 2010. And the monies in the fund prior to 2010 were paid out of revenues earned by the applicant. The SIF did not start magically in 2010. If you are going to look at monies paid in after 2010, you have to look at monies paid in prior to 2010. If that was part of the decision, if that is what I saw in the analysis, I could more say I understand where the commission is coming from. But if you have made no assessment of funds that were put into the SIF before that time, how can the applicant feel that this is fair? So let's get to the numbers that were put into evidence in this matter. Prior to 2010, ratepayers paid approximately $20 million towards general insurance. That's the evidence of Mr. Blackman. The general insurance cost for the same period was $70 million. A $50 million shortfall between what was put in as ratepayer contribution and what was paid out for general insurance. A SIF was put in as a matter of a decision of the applicant. Monies were being put into that SIF. Monies were being put in by the beneficiary under the SIF, the applicant. He's funding it. It is funding it. That money has to come from somewhere. I would suggest that if the money wasn't going into SIF, it would have been available to pay dividends. I would suggest. There was a choice to take the money and put it into the self-insurance fund. So let's come to 2016 when this payout occurs. The right sizing based on expert evidence as what was required to maintain that SIF. The evidence is that they went to CGM Gallagher, they got an assessment done, it's before the commission in this paperwork, as to how much was required. Prior to that, they had an assessment done by CoreLogic. This is not an applicant just choosing to make a decision. It was based on an assessment by professionals. When that approximately $100 million was withdrawn, it equated almost to the dollar of the amount contributed by the applicant up to that period. Almost to the dollar. So when I hear that monies in the SIF belong to the ratepayers, it fails when you first recognize the revenue requirement was never got. It fails when you recognize that the majority of the money in the self-insurance fund was contributions from the applicant prior to 2010. In my submissions during the rate hearing, I said this. Finally, it is submitted, is highlighted that the customer contributions, which were specifically included in the tariff for the SIF, remain in the fund together with interest earned on the initial contributions from the profits of the applicant. The applicant didn't take out principal plus interest, and my friend Mr. Went will love this one. He's big on interest issues. He left the interest earned during the period on the funds it put in out of its profits within the fund. And the total within the fund matches ratepayer contributions. At what point do we get to look at that and say they withdrew ratepayer money? It is inappropriate and wrong for the Commission to ignore the manner of creation and the funding of the SIF up to the year 2010, and it's nowhere addressed in the decision. Solely seeking to make a determination on the basis of ratepayer contributions post-2010, I believe is erroneous and incorrect. I think what I've just said goes to the issue of fairness. It goes to the issue of balance. I've also put case law before this commission that would suggest that even if that was the case, it is a huge regulatory jump for the commission to try to assume that those monies belong to ratepayers. That's a matter of law. And I've learned long enough in this practice that when you just rely on law, you sometimes lose your audience. The law can be an ass. But what I've said before is fairness. What I've said before is equity. How does a commission bring about a decision where it does not look to the creation of the fund, the initial funding of the fund, it only looks to what occurred post-2010? That is not balance. If you want to say it is ratepayer money, explain to me what your determination is in relation to the original contributions. There's a need in these proceedings, Chair, which I think has been lost, to indicate the real-world consequences of the decision that has been given by the Commission. The impression exists that these orders simply restrict the applicant from over-earning, from being overcompensated, which is obviously an obligation of the Commission. We would say the figures show clearly that that isn't occurring, but let's put that aside. the true consequences are likely to be significantly different. The Commission's ruling on ESD, for example, reasonably sends the message that this and similar investments should not be made by the applicant. That's the message. You cannot recover it. We may consider imprudent. I don't know that anyone can read the decision and don't recognize that the message that has been sent to the Barbados Light and Power is that investments in ESD is a questionable one and one that we would ask you to reconsider. So what is that in terms of its impact on government stated policy? You're ignoring the BNet and 2030 obligations. What is that in terms of the impact on customer reliability in terms of service? Related to government policy, and I might call the acronym wrong, the IRRP, but the chair knows what document I'm referring to. There's the indication that the investment in storage devices is necessary for grid stability. If we are going to put this level of RE within the system, we need to protect the grid. If we don't protect the grid, that impacts customers. That means they have outages. That means they have an unreliable service. If you send a message, do not invest in ESD, and the consequence is that government stated BNet policy is undermined, the consequence is that grid stability is undermined, that is a real world consequence. This isn't about overcompensation, non-compensation. I think you have to reasonably accept that the message sent, do not invest in this piece of equipment. And I made the mention of it before, but it's another example of real world consequences. What will this commission do when the applicant chooses to make the effort to get to your debt equity ratio? When it says, I need to pay $25 million in dividends this year, and there's a hue and cry, what will you do? What will you say? When it says, I have to borrow to pay it down, what will you say then? That's a real world consequence of your decision. And I do not know that in the context of a review and a variation, if these matters were not before you in the context of how you analyze the data, I believe you need to analyze it and look. This is an opportunity for you to correct anything that you didn't get right. This is an opportunity for you to put into analysis things you may not have considered. This is an important opportunity to be given.
Mr. Chairman, if I may, I have an objection to this current line of argument by counsel. Chairman, counsel is, in this argument, seeking to introduce evidence, seeking to re-argue the case, new concepts that he's introducing into an evidentiary process that has been completed, an application process that has been completed, and the applicant has had 2 years to put these arguments before the commission. And I would ask the panel to direct counsel not to attempt to give evidence on behalf of the applicant. He's done this several times during this process, and he needs to be stopped.
Yeah.
Thank you, my lord. Sorry, Chair,
yes,
I think I elevated you by accident. My apologies.
Thank you, Mr. Allen. We just would want to caution you as we acknowledge that any information presented this morning that was not part of the original, if it will not be taken into account.
Chair, I totally agree, but I'm confident that you will find every reference in the original. So,
Please continue.
thank you, Chair. It has to be said, Chair, that the applicant is mindful of the Commission's stated concerns. The task the Commission is saddled with is not an easy one. It's an unenviable one. And I would have stated at the beginning of these proceedings that I recognize the effort it took in dealing with the thousands of pages of evidence, the myriad witnesses doing the analysis. And no one wants to be responsible for asking ratepayers to contribute more in what are very hard economic times. But I've outlined some real-world consequences above, which I reasonably believe call upon the Commission to act, review, reconsider, and vary its decision. Do what it's obliged to do in fairly balancing consumer and utility interests in the pursuit of a fair and reasonable rate. The applicant recognizes that as a regulated entity, it does not have the luxury of random unilateral increases to meet its operation and reasonable profit requirements. Every other company out there does it. Transport costs went up, supply line considerations. We need to put on more. X costs went up, pass it on to the consumer. We don't have that luxury. Yet, fair is fair. Just as the applicant is bound by its legislated obligations, so too is the Commission. When assessing the applicant's motion, the Commission must stay within its legislative confines, and that is a major element of the complaint within the motion. The grounds for review and legal arguments made in its review are all buttressed by established regulatory principles. I do believe we are the sole party here to make an effort to repeatedly link its arguments to regulatory principles. We respectfully submit that there's been no evidence or legal argument raised by any intervener which contradicts this assertion. We humbly request that the Commission review its findings, vary its order as requested in the notice of motion. Thank you, Chair.
Thank you, Mr. Allen. And
Mr. Chairman, if I may please. I know you will address it, but I don't want it to be left in the public domain. The idea of a notional position was presented by the chair.
Mr. Wendt?
Yeah, so I don't want it to be misled in the public domain.
Okay, thank you, Mr. Wendt. And what we'll do is we will adjourn. We will take a recess at this time for about an hour and 15 minutes. And when we come back, we will raise a couple questions to the applicant to clarify any constructs that were used during the presentation over yesterday and today. So we will.
As the chair pleases.
Okay.
down here at Birdland this evening, a recording for Blue Note Records.
Sugar pop, rocks and pop. You don't stop till the sweet beat drops. I shall improve as I stick and move. Vivid poems recited on top of the groove. Smooth mind, floating like a butterfly. Notes set afloat, sung like a lullaby. Brace yourself as the beat hits ya. Dip, trip, flip, fantasia.
What's that?
Bitty bitty bop. Drop, jazz and hip-hop, dripping in your dome, it's its own and bop. Funk confusion, a fly illusion, keeps you coasting on the rhythm you're cruising. Up, down, round and round, rhymes profound, but nevertheless you got to get down. Fantasy freak through the beat so unique, you move your feet and sweat from the heat. Back to the fact, I'm the Mac and I know that. The way I kick the rhyme, someone call me a poet. Poem steady flowing, growing, showing sights and sound. Caught in the groove, invitation I'm found. Many tripped and tore upon the rhymes they soared to an infinite height, to the realm of the hardcore. Here we go, off I take ya, dip trip, flip fantasia.
What's that?
Bitty bitty bop.
Yeah.
Bitty bitty bop.
Funky, funky. What's that?
Bitty bitty bop.
Yeah.
Bitty bitty bop.
Funky, funky.
Jump to the jam, boogie woogie jam slam. Bust the dialect, I'm the man in command. Come flow with the sounds of the mighty mic master. Rhyming on the mic, I'm bringing suckers to disaster. Buku ducks, but I still rock Nike with the razzle dazzle. A star I might be. Scribble, jabble, scrabble on the microphone. I babble as I fix the funky words into a puzzle. Yes, 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 on and on as I flex. Get with the flow, birds manifest. Feel the vibe from here to Asia. Dip, trip, flip, fantasia. Ow, you don't stop. Come on, come on, come on, come on, come on, come on. Give me more of that funky horn.
What's that? Yeah. Funky, funky.
Bell on drums, Pooji Bell. Hiram Bullock, guitar.
Okay, welcome back, and just have a couple questions that we would be asking of the applicant to clarify some of the concepts used during the 2 days. So I will ask Commissioner Martinez to ask the first set of questions.
Could you clarify whether any of the Commission's decisions preclude BLPC from recovering the cost of the energy storage device?
I don't believe the matter is precluding. I believe the impact of the decision results in BLPC having to question prudence of certain investments, which is an obligation. But I can't say it precludes.
Could you also clarify how the current stated method of recovery of the ESD runs contrary to the BNEP? Can you point us to the specific section and paragraph which the current recovery method contradicts?
I don't believe it is an issue of the current recovery method. I'm speaking specifically to the decision where the Commission, it could be reasonably said, called into question the prudence of the ESD. And in terms of calling into question the prudence of the ESD, it would mean that there's a need to assess any type of investment going forward. Where the Commission says you need to provide us reports and further information to allow us to do certain analysis, it would suggest that they have not accepted that that is a prudent decision and it's still a period of assessment going on. So I wouldn't say it relates to the process of recovery. I would say it relates to the assessment of the prudence related to the ESD.
Can you also tell us how the Commission's decision dated February 15th, 2023 precludes recovery for future investments in storage?
Similar to what I just said, I don't know that it precludes. It is not the applicant's argument that it precludes a recovery. It's the applicant's argument that the doubt which has been placed over the logic of that type of investment is a concern for the applicant in terms of making its business decisions. But preclude is not the argument that we've put before you.
Mr. Allen, could you clarify your understanding of a regulatory liability for regulatory accounting purposes?
My apology. A regulatory liability?
Mm-hmm.
As it relates to the decision, and certainly my understanding is limited to what I believe the decision would have indicated. And I'm looking at it in the context of the account that has been directed in relation to the repayment of SIF and the account that has been directed in relation to, I believe, deferred taxes. And I am consumed with the intent and the ultimate objective. So my understanding is the decision says and directs that these are elements which we believe the ratepayer should recover. And in the effort to allow the ratepayer to recover, the Commission is utilizing the methodology of a regulatory liability account. So as I said, my understanding of the concept is limited to the manner in which it was utilized to effect certain consequences.
Okay. And in the same vein, what about a regulatory asset? And how could this be used for rate-making purposes? Or is this regulatory liability your understanding of a regulatory asset?
Well, in relation to a regulatory asset, I would understand that there are assets utilized by the applicant in the delivery of its service, which reasonably fall to be considered by the Commission in setting what is a fair and reasonable rate, determining whether it is an asset which the applicant would be allowed to recover or it is an asset which you believe is an imprudent investment. So regulatory assets in that concept, I imagine, relate to those assets utilized in the delivery of the electric service.
Okay. And could you explain what rate-making consequences would be for remaining with the use of the IFRS standards for depreciation? What are the rate-making consequences be?
Okay. My understanding, Chair, is that in this example, the IFRS standards were not utilized in terms of any regulatory filing. They were separate and distinct accounts which the applicant carried. And the applicant followed the directions relative to its regulatory filing and sought to follow IFRS obligations in relation to updating. Now, I would have made the point that the updating that would have occurred following those IFRS standards would not have resulted in any change of charge to a ratepayer. At the end of the day, the ratepayers contributed in terms of accumulated depreciation expenses what was determined in 2010. So that is why I said the only possible effect of that updating in terms of IFRS standards would be in relation to the rate of return which was under consideration, where you might have said if you hadn't updated, you would have had a better rate of return. But in terms of what I would consider then to be your primary concern and objective, that is ensuring that a fair and reasonable rate is not an overcompensation. If the rate of returns that were recognized over the number of years never rose to what was agreed or sanctioned, even if that number is wrong, I don't know that it should be a concern for the Commission in terms of did this applicant receive more than it was entitled to.
So could you clarify your understanding of the consequence of having a regulatory liability account for accumulated depreciation?
A regulatory liability account for, repeat that question.
Could you clarify your understanding of the consequence of having a regulatory liability account for the accumulated depreciation?
Excuse me, Chair. Thank you, Chair. I don't want to fool myself that I can move into your domain without some support. The concept, and I believe the impact, is that there is a diminution of the rate base. And if you have that regulatory liability account and obviously impact on the rate base, it means you're then impacting on the consequential order as to what is a fair and reasonable return. So I believe, and I'm not using the word in a negative manner, it's, if there's a valid basis, it's not an issue for the regulatory liability account. If it's not a valid basis, it's almost a confiscation of rate base. By a reduction in the rate base when you utilize that liability account.
So in the evidence that we considered, we would have noted that there would have been a difference between the IFRS accumulated depreciation and the regulatory accounting depreciation. And hence there was a difference. Now, how was the amount in the regulatory accounting that would have been part of the rate base?
Correct.
Okay. And did your analysis revealed that amount to be greater than or less than the IFRS balance?
I believe subject it would have been less than.
The IFRS would have been less than?
No, the IFRS would have been greater, the cost.
No, confirm.
I'm not as bad as I thought. It would be higher with the IFRS because the rate of accumulated depreciation, is that what you're asking?
Was asking the actual amount in the accumulated depreciation under the IFRS compared to that under the regulatory accounting, because
It's less.
yes,
My apology, I
right,
misunderstood you.
It's less.
Yeah.
So there would have been a difference of approximately what, 32 million?
I would take your direction, Chair. I don't know the number off my hand.
But you can consult with your.
Yeah. Is it 32?
It's about.
Chair, 32.1 million, if I may provide the figure for you.
You're correct, 32 is the figure.
Right.
But I would remind that that would have also related to certain assets that would not have been covered by the 2009 determination. AMI, stuff that was not in existence in terms of the 2009.
Okay.
So you would have
Chair.
other areas covered that were not within the 2009 decision.
Chair, I believe that the panel is being misled on this issue because there was provision in the application, the 2009 application, in relation to meters, yes, and certain information technology upgrades. Those expenses were included in that rate case.
Okay, thank you. I just wanted to focus on the whole concept of the regulatory liability that is one of the regulatory liability in relation to the accumulated depreciation. And we're just asking you to, in your understanding, the difference between the accumulated depreciation under the IFRS compared to that under regulatory accounting. And we just wanted to confirm that the applicant understood that there was a difference where under IFRS it was $32 million less than what the ratepayers would have paid under the regulatory accounting. I'm just trying to...
I agree, Chair. I'm not disputing that.
Right.
But I think it's relevant, as I said, and if my friend wants to take issue with upgrades, I think the Commission will accept there were assets not covered by the 2009.
Right, but we're looking in terms of the accounting treatment, and we're looking in terms of the accounting treatment, that there's a difference of 32 million that we were asking to create as this regulatory liability. So we were just asking, what is the consequence, for you to outline if there would have been a consequence of asking that the company put this 32 million into regulatory liability as a result of the difference between the IFRS accounting versus the regulatory accounting.
As I indicated, Chair, and I stated what the consequence would be. I imagine the determination for the Commission relates to the equity or fairness of putting it into the regulatory accounting in a situation where, as we have indicated, there are other elements which we are not sure you have considered in determining that there's this loss to the ratepayer.
Okay. I would ask Commissioner Scott Joseph to answer another set of questions.
Mr. Allen, could you tell the Commission your understanding of notional capital?
My understanding of notional capital relating to a assessment of the capital structure of the entity and the part that notional capital plays in it? Yes. Okay. My determination or understanding is that an entity's financing is either going to come between two elements, debt, capital. And when you indicate what you consider or call a notional, it's your indication, the Commission's indication to the applicant as to the level of that element that the applicant should seek to strive to reach in terms of its operations.
Okay. What do you perceive to be the real-world consequences from the use of notional capital?
I don't know there are any real-world consequences from the use of notional capital. What I believe is that there are real-world consequences if the applicant makes the effort to meet what you have indicated is the notional capital structure. So the notional capital in of itself doesn't have real-world consequences. The word notional in itself means that it has no real impact. The question, I believe, for the Commission is, when we set it, what is our signal to the applicant in terms of what it must do or what it should strive to do in terms of managing its capital structure? We would be clear that based on the numbers that have been received, many years the notional structure has not been attained, and I believe there was some evidence as to where the actuals as opposed to the notional existed. But notional simplicity does not have any real-world consequences. I think it's what the applicant then does in its efforts to meet what you have set out in your decision.
Mr. Chairman? Mr. Chairman, I did raise this one, and I'm pleased that the Commission is asking about it. Now, in regulatory terms, as the Lighting Paul did in 2010, their debt equity was 80-20, and their proposed 65-35 for rate-making purposes. In this particular application, their equity is around, I think they said 75 to 70-something%. That's if you include the CEB. And now they wanted to stay with a 65-35 equity. The Commission, looking at the average as it did back then, arrived at its 55-45. The key is that the notional equity is no decision by the Commission to tell the company that it should get to 65-35. It's for rate-making purposes. So this issue that the company is arguing, we need it very clear in the audits. You're not living here to tell the company, we need you to try to get to 55-45. Mr. Chairman, I hope that that is helpful.
Sorry, Chair. No
You
further.
wanted to respond to, I saw you consulted.
No, I was just checking.
Yeah, what Mr. Went said is true?
No. Unfortunately, I wasn't even listening to Mr. Wayne. No offense to Mr. Wayne.
That's where the problem is.
I was focused on making sure that the answers I give the Commission are true. That's more a focus of my attention.
Your findings?
So far, it seems I'm doing pretty well, Chair.
Now, in your submission, you indicated that the test year expenses were not adjusted. You may wish to note that adjustments were made to test year expenses in Section 4, paragraphs 117 through to 126, and in Section 5. So could you identify the corollary expenses that were not adjusted?
Could you repeat those figures, Chair? Section 4, 117.
To 126 and Section 5, test year expenses and revenues. Section 4 deals with test year expenses and revenues. And Section 5 deals with depreciation.
Here you're referring to the decision, correct? Yeah.
The decision, that is what this, you're asking us to review the decision.
Chair, the issue for the applicant is the input costs that were not assessed in these sections, such as lubricant and other input costs that would have faced inflationary pressures.
Could you repeat?
Certain input costs, Chair, example being lubricants. So we are saying that there was not an assessment of the input costs associated to the period which you have highlighted will be your determined test year.
So there's a clear understanding by the applicant the difference between variable expenses and fixed expenses?
Yes. Certainly, if not by me, Chair, by those who advise me.
Okay. And it is your submission that the variable expenses were not considered in making the adjustments? Because I've only heard you indicated lubricants. That's the only one that wasn't adjusted?
Okay. Chair, let me give you a full list so that you...
Well,
yes.
okay. Well, okay.
Thank you, Chair. I'm understanding that, as you said, lubricants is an example, but there's also the inflationary costs that would have impacted on those elements of the expenses. Some fixed costs, such as maintenance. There's a full, as I said, I believe the accounts would review a more fulsome list if it is an element that you would like us to provide to you and the interveners. It is something we can do. This is not new evidence, let me rush to say. Anything I provide to the Commission and the interveners will be taken from the evidence that is already before
you. Mr. Chairman, it would be particularly helpful if the applicant could make very clear the adjustments as was done when the application was filed. The applicant set out very clearly the known and measurable changes that were included in the application, which is then arrived at to arrive at the revenue requirement. Now, what we'd like to see, for your question is very pertinent, what it is that the Commission has not considered in arriving at the revenue requirement that the applicant is worried about. And those has to be very specific. So just as the applicant said for the Clean Energy Bridge, the $133 million had a revenue adjustments on depreciation of $5.3 million. We're happy with that. The applicant had also said that because of the same Clean Energy Bridge at Trent, the non-taxable income increased by $1.2 million. So those things are very clear because that would then allow the commission to be clear. So if it is anything that the applicant wants to clarify in the known and measurable change, we should see that very clearly. Thank you, Mr. Chairman.
Mr. Chairman, perhaps I can also be helpful to the Commission. Council has referred to, for example, lubricants. I believe he's saying it's an adjustment that needs to be made, but I refer you to page 000733, explanations and comments on adjustments, and that specifically is there as an operation and maintenance expense adjustment. And so I think you need to very carefully consider what is being said here. Certainly on that point, you've been misled.
Chair, let me just say that we thank intervener Watson for her assistance, but I believe the argument is that when the Commission changed the period, that information would no longer be totally on point without a similar adjustment to match period. In relation to information that is before you, and also specifically sent to intervener Wendt, Exhibit RB3, an interrogatory in response to a data request. There would have been a forecast stated within that interrogatory 23, 24, 2025, which would match the, speak to the period that is under consideration and the applicant's concept of the expenses to be incurred. That is Exhibit RB3, response to Mr. Wendt. And I repeat, the simple argument on this is that if you adjust sales to 2022, you need to adjust the expenses to 20. I'm not taking issue with any change in test year. I'm not questioning your right to change the test year. I'm just asking for a matching of revenues to expenses.
Mr. Chairman, I think this last one for me. I think the Commission is quite clear on that. You did indicate that in the order. You would not want a mismatch. So if it is that you prescribe and said, look, we want to see that the revenue of 2020 doesn't reflect the revenue once COVID has passed, so we'd let you look at 2022 or 2021, whichever. Correctly, the board is not going to want Lighting Power to look at the adjustment in the revenues and not the expenses. I wouldn't expect that at all. So if it is that it was not said in the order, it is not to say that the Commission do not expect that appropriate adjustments would be made. So if there's any doubt, please make sure that the applicant is well aware that we don't want to play any games. If it is that there are genuine expenses that need to be adjusted as a result, that's fine, for the exact same period.
Thank you, Mr. Wendt, and I do believe that that is a valid submission, and we'd heard that submission from all of the interveners that there would have been no objection to any known and measurable adjustments that needed to be made. So we were just asking you to identify and point us to the specificity to ensure that we are not in any way disadvantaging the applicant. But we just want to be certain, because it was a statement that was made that we did not.
A fair request, Chair. As I said, I believe it may be helpful if I provide that to the Commission and to the interveners. And as I said, I will only reference evidence that has already been filed
submitted
to you.
Chairman, we would presume that that information is already contained in the March 7 compliance filing that we are yet to receive, might I add.
Just ask that they would point us to the relevant section in the application and the information that we would have on file, that we will be able to do that. So
Quite fair, Chair, not an issue.
Well, I believe we would have sought some areas of clarification, and we will now consider the whole record to make our determination, and we would report our decision based on the whole record. Just want to remind that any information that was presented that was not part, that spoke to the motion would not be considered. We'd only be considering the information that is relevant to the motion before us. So I would thank you for your participation here today, and we will now. You have a question, Mr. Allen?
No,
Sorry, your
Chair.
mic was on.
I just wanted to say thank you and thank to the commissioners in terms of this effort.
Yeah.
I repeat what I've said previously. You do not have an enviable task, and it is not that this is in any effort to castigate the efforts made to date, but I believe the process is set up within the legislation allows you this opportunity to review, consider, and I think it's a solid process within the legislation. So thanks to you and your fellow commissioners.
So I want to thank the applicant as well as to thank the interveners, as well as the staff and those who would have attended the hearings and participated. And we will now adjourn to consider all of the information that is properly before us, the whole record, and we will make our determination and we will issue a decision at some time in the future, having considered the record. So thank you once again for your participation. I do wish all of you a very good day.
Thank you very much, Mr.
Thank you,
Chair.
Mr. Chairman.
Thanks, Mr. Chair.
All right.